welcome to this training on sexual harassment in the workplace. My name's Rachel Davis and I'm a senior lawyer at Knockhold Solicitors. Sexual harassment has been unlawful under the Equality Act since 2010, but a new duty has come into place on the 26th of October 2024 under the Worker Protection Amendment of Equality Act 2010 Act 2023. And this new legislation imposes a new positive mandatory duty on employers to take reasonable steps to prevent sexual harassment of their employees during the course of employment, as well as preventing harassment from third parties. So the reason this new law has come into place is because there's been a lot of consultation since the Me Too movement, which started in 2017. So you probably all remember this. This was when an American actress tweeted the Me Too hashtag to say that she had suffered from sexual harassment in the workplace, and she wanted to identify the magnitude of the problem. And what she did, she asked anybody else who'd suffered from any form of sexual harassment or sexual abuse, not just in the workplace but in society as a whole, to retweet this hashtag #MeToo. And this took on a domino effect, and millions of people all over the world were repeating this hashtag to say that they too had suffered from some form of sexual harassment or abuse or inappropriate behaviour in the workplace. And the Me Too movement has resulted in a huge increase in media attention on sexual harassment, particularly at work, and it's given individuals more confidence to speak up about their own experiences, knowing that they're not alone. There's been an increase in the number of complaints being made to employers, as well as much greater oppositions to situations that employees don't agree with in the workplace, not just relating to sexual harassment. And what this has done, there's been a lot of media attention on it, and people and high-profile individuals and high-profile organisations are finally being held to account for historic events of sexual harassment that's previously been covered up in the workplace. So I'm going to start off just by going back to the definition of sexual harassment under the Equality Act 2010. So the legal definition is set out as unwanted conduct of a sexual nature which has the purpose or effect of violating a person's dignity or creating for that person an intimidating, hostile, degrading, humiliating or offensive environment. So I will go down to break that definition up into the different sections. But what also is important to remember is sexual harassment also occurs where the individual either rejects sexual advances or accepts them, but is subsequently treated less favourably by the harasser. So this might occur in a workplace, for example, where you've got a senior male manager who propositions a more junior female member of staff. She rejects that advance or says, no, I don't want to go out for a drink, or just rejects that advance in some way. And then he very subtly but intentionally can block her for a promotion, block her from training opportunities, or very subtly make derogatory comments or unwanted criticisms, which other people may not notice, but that is a form of sexual harassment as well. So just going back and breaking down that definition of sexual harassment. So unwanted conduct of a sexual nature. So it's fairly self-explanatory, but it's things like sexual comments, jokes, suggestive looks, staring or leering, propositions or sexual advances, and physical gestures. It can also be unwelcome touching and hugging, and written words such as on email or social media. And what's important to remember as well, sexual harassment can just be a one-off comment or a one-off incident. It doesn't have to be a series of events that has gone on over a period of time. And what's also important to remember is that it can happen to anyone by anyone. So overwhelmingly it does happen to women by men, but it can also happen to men by women, and it can happen from people in different positions. It can happen to junior members of staff, from senior members of staff, and the other way round. So this does unfortunately happen to anyone by anyone. So people often ask, what about this subject of banter. So banter is where there's just acceptable jokes in the workplace, everyone gets on. But it's important to know that tribunals are now more and more rejecting this excuse as a defence or as a justification for sexist remarks, particularly where it encourages a culture of harassment in the workplace. So it's important to remember that you should be mindful of your jokes or comments in the workplace. Everybody has different sensitivities and different feelings. And where one person might find a comment funny, somebody else might find humiliated by that. So it's difficult for people to understand when banter becomes unwanted conduct and where that crosses the line. But it's important to also remember that even when somebody's seemingly engaging in banter, it doesn't mean that they're accepting it. It just might mean that they don't know how to deal with it, they don't know how to complain about it. So somebody might just go along with it even though they're not happy with it. So it doesn't preclude a successful claim for harassment, even when you think somebody's going along with a joke. So the next part of that definition is the purpose or effect that unwanted conduct has. And when the tribunal is looking at this, the motive of the harasser is irrelevant. So the alleged harasser might be, totally dismayed by the allegations and saying, I didn't mean to upset anybody, I didn't mean it to have that effect. But the tribunal won't take that into account. What they'll take into account is how the individual felt in response to that unwanted conduct. So the tribunal will take into account things like, was it reasonable for the conduct to have had that effect? Is the person overly sensitive? Are they vulnerable, for example, because they've been subjected to sexual harassment in the past? So they will look at all those different situations. Would a reasonable person, a different person in that situation, have felt degraded or humiliated? But what they won't look at is what the harasser meant, the effect that the harasser meant by that conduct. So the next part of the definition is the conduct has violated somebody's dignity or created for that person an intimidating, hostile, degrading, humiliating or offensive environment. And that unwanted conduct doesn't have to be directed at the victim for it to be harassment. So for example, you could have somebody in an open plan office, there's two people at one side of the office having a bit of a joke or looking at something on their laptops that they're finding funny. Somebody in a different part of the office who isn't included in this conversation, hasn't been invited to join in, but overhears the comments. That person can be subjected to this intimidating and degrading environment. They can then bring a claim for sexual harassment because of that conduct. So it's always important to be aware of your surroundings and who might be there and who might be overhearing your comments. So we also talk about the employer's liability. So the employer is liable for the actions of their employees during the course of employment. So we're often asked, what is during the course of employment? It's clear that it's while you're in the workplace between the hours of 9 and 5:30 or whatever your working hours are. But this duty extends far beyond the workplace. So for example, the employer can be liable for acts of their employees when you're out at a social event, when you're out at a Christmas party. And this is obviously where a lot of these allegations start. So it's important to remember that when you all go out to an event, to a social event or to a Christmas party, you're all there together as a company or you're all there together as a team. That will be classed as being during the course of employment. And anything that happens there can be the employer's liability, whether or not the employer is aware of that or not. So the new preventative duty also includes prevention of sexual harassment by third parties, so not just by the employees or the colleagues. So therefore, if an employer doesn't take reasonable steps to prevent the sexual harassment of their workers by third parties, this duty will be breached. So when we talk about third parties, we mean people like customers, clients, or members of the public that employees come into contact with during the course of their employment. So it's important to remember that employers can't be expected to do everything. They're not in control of third parties. They're just required to take the reasonable steps, do all they possibly can to prevent this harassment by third parties. And when looking at a claim of this nature, the tribunal will consider the employer's overall approach to preventing and dealing with sexual harassment when considering whether these reasonable steps have been taken. So employers have a statutory defence if they can show that they've taken all reasonable steps to prevent harassment. So the steps will be things like carrying out training of the staff, having policies in place, having a complaints procedure in place. But what is reasonable will vary from employer to employer, so it will take into account the size of the employer. So for example, a bigger employer with more financial resources is going to be expected, for example, to do more training sessions, have updated policies. Also, the nature of the workplace is important. So somebody working on a factory floor may have different rules in terms of conduct and the type of language you can use than somebody working in an office environment. And also looking at the risks present in the workplace. So for example, how often are staff likely to become into contact with third parties? How often are they working on their own? So it's important that all these risks and factors are taken into account when thinking about the reasonable steps that you need to take within your business. So employers should be able to demonstrate that they've taken these proactive steps, and there is some guidance on the Equality and Human Rights Commission's website, but basically the main steps to take are undertaking risk assessments like you would with any form of health and safety risks in the workplace, anticipate the likely risks of those things happening, and then taking reasonable steps to reduce those risks. This includes things like updating and creating and distributing a sexual harassment policy, so everybody knows what is acceptable in your workplace, what the rules are, and outline a clear reporting procedure. Conduct the periodic training and refresher training of all staff, all managers in your workplace. Make sure complaints are investigated and actions taken where any wrongdoing is identified. So that's an example of the reasonable steps that companies should be taking to prevent sexual harassment. So the cost of harassment claims. So these claims very rarely end up in an employment tribunal. They're usually settled throughout the internal complaints procedures of a company. But if these claims do end up in an employment tribunal and somebody's successful in a claim for sexual harassment, they will be awarded financial damages. So this is a financial loss to the company. So they will be awarded financial loss for their loss of earnings. So for example, if they've had to leave their employment because of this conduct, they will be awarded loss of earnings. They will also be awarded an additional award, which is called an injury to feelings award. And this is set out in an old case called Vento and Chief Constable of West Yorkshire Police back in 2003. And what this case does, it sets out the different bands of injury to feelings financial awards. And this depends upon the seriousness of the harassment. So for example, a one-off comment or a one-off inappropriate conduct would be set in the lower band, and somebody will be awarded compensation of up to around 11,700. Whereas more serious cases of an ongoing campaign of harassment, for example, very serious allegations of harassment that are found to be true, can be in the upper band up to almost £60,000. So these can be expensive claims in terms of financial cost to a company. The individual claimant can also claim for personal injury. So if they've suffered, for example, psychological damage as a result of the conduct, and very rarely, but this can happen, aggravated financial damages are awarded, where, for example, the employer hasn't done anything about this sexual harassment, or where they've even promoted the harasser. But what's more important to companies than the financial damages is the damage to company reputation. These things stick. People don't want to work for companies that have this type of reputation, and this then has this adverse effect on retention and recruitment, and then it becomes very difficult to keep and retain and recruit staff to such a workplace. So for employees and all members of staff, it's just to remember your role in the workplace. So just to remember that any jokes, remarks or banter might cause offence to other people, and they won't be tolerated. It's realising that colleagues will have differing views and feelings and different levels of sensitivity about certain matters. So it's to be aware of your surroundings, be aware of what you're saying and what you're doing, and just be mindful of your impact on other people at all times. As a witness, so if you witness some inappropriate behaviour, intervene if you feel that you're able to do so. Close down inappropriate comments and behaviour. We want everybody to get used to saying things like, that's not appropriate, that's not tolerated in this workplace, you're upsetting people. So it just becomes natural for everybody to do that. Support the victim. They might not feel confident in going and reporting the inappropriate behaviour, but encourage them to do so. Offer your help in doing so, and also cooperate into any investigation into the incident. The role of a line manager, so you've got an extra role, an additional role. You need to lead by example, so you need to be identifying inappropriate conduct. Any of this banter, inappropriate behaviour, closing down comments at the outset, just letting people know that isn't tolerated. If you need to speak to somebody, take them to one side, speak to them separately. Let them know that that behaviour isn't tolerated in your workplace. Let them know that they might not have realised it, but they're upsetting people by making those jokes or making those comments. Make a written note of any discussions you've had in case you need to come back to that at a later date. And also decide whether this is so serious that you need to conduct a full investigation. What's important is to act promptly. Don't delay, and make sure these things aren't swept under the carpet. So if an individual is being sexually harassed or feels uncomfortable, or if you witness somebody being sexually harassed, in the first instance, it's always advisable to try and resolve these matters informally. Consider raising it with the person responsible, because that person's probably going to be absolutely horrified that this is the case. They're going to apologise, and it's just going to stop it at the outset. They won't do it again, and you can shut that down and the matter's resolved. If you don't feel comfortable raising it with the person in the first instance, then speak to your line manager or the HR department for support. They will give you support, and they'll help you resolve the issue informally if that's what you'd rather do. It's just important that this behaviour is identified immediately and that it's shut down from the start. If the matter can't be dealt with informally, then your company does have a formal process to deal with this. So you will be encouraged to raise a formal complaint or a grievance. This will just follow your formal internal company procedures. But the general route is that an investigation will be carried out, a meeting will be arranged with your HR or your line manager, and a confidential formal process will be followed in accordance with your company procedure, which will result in an outcome to that formal process, which will then decide upon what action will be taken. As a manager, you may be responsible for conducting an investigation. So as you will be aware, any investigation as part of an internal process should be conducted by an independent person. So somebody who's not going to be involved in the subsequent grievance or disciplinary process, and somebody who obviously hasn't been involved in the incident. So it's very important to conduct an investigation within a reasonable time frame. This is to ensure that witnesses' recollections remain fresh and accurate, and also to obtain any useful documentation that might otherwise be destroyed. For example, if it's something from a Christmas party or a social event, you may need to obtain copies of CCTV, which sometimes gets destroyed within a certain period of time. So even if you think that you might not be needed later down the line, it's important to get that at the outset just in case it is. And again, it's important to follow a confidential process, as with any other formal process within your company. Any witnesses need to be interviewed if they can contribute to the facts of the case. Some witnesses might not want to give witness evidence about their colleagues or about their managers, but it's important to just try and reassure them about the process, address any concerns, support them through the process and explain the relevance of their information. You will then need to make a decision on the factual evidence, so not on instinct, not on opinion. Obviously, witnesses are going to come forward perhaps after a social event. They're going to be giving their opinions on what happened, but it's your job to be able to decipher what's fact and what's opinion, and to then just put forward the factual evidence. And of course, don't discount any evidence that points to the victim's innocence. So it's taking all that evidence into account so that then you can make a decision on the outcome of the investigation. You will then be responsible for writing an investigation report with your outcome. So you'll generally set that out with the summary of the allegations, the issues you've investigated, all the evidence you've considered, all the witnesses you've interviewed, and then put within that investigation the minutes of the meetings. So you've got this outcome and your investigation report, which you then pass on to the next person who's then going to deal with the next part of that formal procedure. So the sexual harassment policy is an important part of this process, and the company will ensure that your policy has been updated, reviewed and